Aloha, this is Professor Porter. Here we're talking about the Federal Rules of Evidence and the Introduction series. And I always start when I teach evidence with this slide and this quote because I think it helps people new to evidence. It helps new students to evidence understand that it's all about a command of the rules and arguing under the rules. And we have to think of the judge as someone that we can inform and give the information and make persuasive arguments under the rules. You understand what I want you to understand when you're talking about the dance is you have these roles that we've been talking about. We're over at sidebar here, but the woman on the left is operating as the proponent. She was the one that was standing up, presenting evidence, putting on evidence. Maybe she was asking questions of a witness. Maybe she was putting on a documented evidence through that witness or some other form of evidence. The gentleman on the right, that's the opponent. He was charged throughout trial, likely sitting down and charged with objecting, getting in the way of evidence. And they made their way over to sidebar because presumably he stood up with a clear enough voice to stop the proceedings, said objection and offered some basis, and that's why we're here. So I want you to think about this dance with these roles because it's the same for all of our objections. It's the same for the whole evidence code. And remember to keep in mind that where are we question. If we're over here at sidebar and we're arguing about evidence, but it's a preliminary hearing, or if it's a sentencing, or if it's some other environment where there's no jurors and the rules of evidence don't apply, that's part of where are we. Also, if the opening line of the sentence says in Montana state court, or in military court as opposed to in federal court, that where are we is going to help us understand what rules of evidence apply. Maybe it's the Montana state rules and not the federal rules. And finally, where are we, are we in a civil case? Are we in a criminal case? That makes a difference in some of the rules. Part of what's fueling this argument, part of what brings us to the point where we object is this thoughts going on. That's this thought bubble. That's this gray thought bubble. What is the proponent trying to do? I'm trying to get into the head of the person presenting evidence. They don't share with me their trial strategy. They don't share with me their trial presentation. So I don't know exactly what they're doing as we progress. But when I hear the questions and when I see what's going on, I start to, as the opponent, form my own thoughts about what is the proponent to do. And really what that comes down to is what is she trying to prove? How is she trying to get at something? And is it permissible under the rules? If it's not, as the opponent, the gentleman on the right, we're charged with objecting. We have to get in the way of that evidence. So if she's trying to prove something and going about it the wrong way, I have a duty to object and keep that improper, inadmissible evidence from the jury's ears. So it culminates in this, no matter what the objection under which article or which rule, it's always standing up at the time and saying out loud the word objection and then followed by a basis for that objection. So it's objection irrelevant, objection unfairly prejudicial, objection improper character, objection improper impeachment, objection improper opinion, objection lacks authentication. These are evidentiary objections, objection hearsay that map into the different articles under the rules of evidence and the different rules that govern the evidentiary discussion. So it starts with the opponent, any evidentiary discussion, objection, then followed by a basis. Arguably why we're using the sort of brief version, just the objection and just the basis, just those few words, and not a longer version, which is sometimes called a speaking objection, where I go into my whole argument. We're doing that because we can say the word objection and we can say the basis for objection in open court to stop the proceedings in front of the jury. Anything more, we should be here as depicted in this video. We should be at sidebar. And think about it, no matter what the objection, as soon as that opponent stands up, objection basis, and we make our way over to sidebar, the dance has begun. After objection basis, we're framing it. Your Honor, this evidence should be admitted. She was the proponent. She was trying to put in evidence. She was trying to ask questions of a witness. She was trying to do something already. So of course, as she makes her way over here to sidebar as part of this dance, she is wed to the argument of, no, I should be allowed to do what I'm doing. Your Honor, the evidence should be admitted, or my question should be allowed. And part of that is, think about that trial court ruling, and his objection should be overruled. So no matter what the objection, when she's going over there, she has this sort of front half of a sentence to rely on no matter what. She was trying to do something. She was trying to go forward in her presentation. She was trying to put on evidence as the proponent. Your Honor, the evidence should be admitted and his objection should be overruled because. That's an evidentiary argument. And just think, after that because, we're probably going to get into the rules. She's going to use the operative language of 401 if he said objection irrelevant as his basis. She's going to use the operative language of 801C under hearsay if his objection was objection hearsay. But she can start out with these words as she's thinking and formulating. It's always the case where the proponent wants the evidence admitted and the objection overruled. That is their side of the dance. And the analysis comes from, and your knowledge of the rules comes from, using the operative words after the word because. From that point, you can imagine the opponent is the one that threw the flag on the field. The opponent is the one that stepped up and said objection hearsay, objection irrelevant, objection improper character. They're the ones that came forward with an evidentiary objection. So this is their extended version that they can now say at sidebar to the court. The evidence should be excluded. Yeah, we know that's their stance. Why? Because they already yelled out the word objection in court. And you should sustain my objection. I made my objection. Now I'm telling you what to do with the evidence, Your Honor, and I'm also telling you what you can do with my objection. You should agree with it. You should sustain it. And again, I'm going to offer some why. I'm going to offer some analysis because. And if I'm making an objection relevance, I'm going to use the operative language of 401. There's absolutely no tendency to move any effective consequence in this action would be more probable than without this evidence. I'm going to use the language to make my argument after I say these magic words. Then with any evidentiary argument, it's always going to culminate with the trial court. And I make students not only play the opponent who's objecting, the proponent who's presenting, and then responding to the objection, but also the trial court. And that's whether it's an essay, a multiple choice, or just classroom discussion. And so as the trial judge, you got to think in this way: what happens to the objection, what happens to the evidence, and some reasoning because. So there was this relevance objection that was raised by the opponent, responded to by the proponent over here at sidebar. I had the benefit of trial judge of listening to that. My turn, counsel. Your objection is overruled and the evidence is therefore admitted, which means it's coming in because the evidence is relevant. And I would use the operative words of the rule even as the trial court. Your objection of hearsay that you brought to us and why we came over to sidebar. I heard objection hearsay in open court, then I heard the proponent respond, then I heard a more fulsome explanation from the opponent as to why he felt that it was hearsay. Based on that, my turn, counsel. Your objection is sustained, which means I agree with it. And the evidence is therefore excluded, or it's coming out. Then it's not going to be admitted if it's a documentary evidence, and it's not going to be allowed if it's a question, because maybe it does violate the hearsay rule. It does violate definitional hearsay, and an exception does not apply, as the proponent was arguing. So I got to handle, if I'm the trial court, at the end of an evidentiary discussion, what happens to the objection, and therefore what happens to the evidence. And unlike a real trial judge, give you a reasoning, because tell us why. And I like to end like this. The court, I'm a law student that grades my own paper, so lawyers matter, arguments matter, and of course your mastery of the rules of evidence matters. Thanks for your time.